What is up, attribution enthusiasts, and welcome to the 13th episode of Attribution Radio. But this is a lucky number 13 because we got a very special guest speaker. Faith Kasparian is here on the pod, and she's an attorney specializing in data privacy and minimizing business risk from a legal perspective. So check this out, Attribution Radio, Law and Order Edition.
Okay, so let me give a quick introduction. Faith Kasparian, I've worked with her before in a different life. She was my privacy attorney, helped me kind of figure out a lot of the DPA, as they call it, right? Data privacy agreement or something like that. And she helped me write that. And that's how I got introduced to Faith. She was a phenomenal coach for me in helping me navigate what mind-numbing privacy regulation. And we've stayed in touch. And I asked her if she could come to class and educate us a little bit about privacy and compliance and laws and all the really painful things that we as leaders have to navigate. And she was gracious enough to agree. Faith, why don't you give yourself an introduction? What do you do nowadays? Let us in a little bit.
Hello, I am so glad to be with you today. So my name is Faith Kasparian. I lead the data protection practice at a medium-sized 40-person firm called Morse, and we are just outside of Boston. We focus on general corporate, employment, litigation, intellectual property, and data protection. We do all aspects of data protection, compliance with the international laws such as the EU's General Data Protection Regulation, the GDPR, just kind of rolls off the tongue, the California law, the CCPA, and everything in between. We do incident and breach response. We work on contracts like data commercialization agreements, data processing agreements. And we really take a practical approach because if you're a small to medium enterprise in particular, there are a lot of laws in this space and it is very hard to comply. But we're going to talk a little bit today about how you can comply, even though there really is a patchwork landscape. And I'm delighted to be here. I loved working with Madan when he was a client. He is a master of this attribution marketing. So yeah, you're with the right person here. And it's my pleasure and honor to join you.
And she is absolutely right. It's incredibly complex, and she made it very simple for us to comply. Which is kind of why I think it would be a phenomenal addition to this literature that we're putting together. So before we start, Faith, what is PII? Just can you tell us what is considered private, personally identifiable information?
Okay. Start. So I'm going to ask a question of the class. If you answer the question right, then I will send you some kind of special gift card. So in the United States, there is one definition of personally identifiable information. True or false? You have to put your camera on if you're going to answer. True or false? One definition of personal information. Anybody want a gift card? Anybody?
False.
Hi, Sean.
Hey. Oh, wait, Kevin answered too. I put false.
Oh, correct. Okay, so Kevin and Sean both get a gift card. Okay, that you are correct. False. In the United States, we have a patchwork of laws, and there are multiple definitions of personally identifiable information. When we're talking about our breach notification laws, it's a more narrow class of what we would consider very sensitive information. Name and social, name and financial account number, name and driver's license number, username and password that would permit access to an online account, just as examples. If we're talking about the COPPA statute, that's our children's privacy statute. We're talking about data of children under the age of 13. HIPAA, we're talking about healthcare data. Gramm-Leach-Bliley, we're talking about financial data. And if we're talking about our comprehensive privacy laws that are starting to be enacted at a rapid pace by our states, we're using a definition that's actually taken from the GDPR. And that definition is anything about an identified or identifiable natural person. Name, business contact details, business email address, IP address in most circumstances, what a consumer has happened to purchase, their purchasing habits, everything. So anything about an identified or identifiable natural person. And that is the standard in Europe. And that is the standard we are starting to see, certainly for our comprehensive privacy laws that are being enacted on the state level. Okay.
There was a question from Vishal about an hour back in class. Vishal, you want to ask the question again?
Yeah, so if you were to, so we were talking about Google Analytics, how you cannot share PII to Google Analytics, but my question was around if you shared an identifier that you can then map back to a PII in your systems, is that still a violation of some privacy law? Yeah.
Well, it's not a violation, it's just regulated. And so I think it would be important to talk about what's not PII. So not PII is anonymous data, or aggregated data. But for it to be, for it to constitute anonymous or de-identified data, the standard that you should look to is the EU standard, and that is the data cannot be re-identified by any means reasonably available to anyone. So like in the EU, there is two lines of precedent, or there are two kind of schools of thought. One is if an IP address alone is handled and the business that holds that IP address does not have any other information to tie the IP address, let's say, to that individual, can't use it to contact the individual, then there's one school of thought that says, well, then it's not personal data. There's another school of thought that says if the internet service provider has information that can tie the IP address to the individual, then it is personal data and it's regulated. So you don't want to be thinking that it's a violation necessarily to handle data that's identifiable. It's just that there are obligations that attach to that information.
Okay. Would you mind just unpacking this a little bit? Suppose Vishal has access to Google Analytics, like a ID or some sort of a user ID. That user ID in the back end has an email address, not in the front end, in the back end. If he saves the Google Analytics user ID to the database at some point, now, what kind of protections does he need to give the Google Analytics ID? Does it just now become like PII and he needs to treat that like PII and handle that like PII? Is that what happens to him?
Yeah, so in the case that you're talking about, you're handling that ID and the back-end email address for the purposes of your business. Is that right? Maybe to decide what kind of advertising to send to the individual that's associated with the email address and the IP address. So at a high level, if you're collecting the information, let's say online, even outside of the new comprehensive state laws, you need to have a privacy policy that describes what you're collecting, how you're using it, how you're sharing it. There are at least a handful of states that had online privacy policy requirements. If you're talking about GDPR, or if you're talking about the comprehensive privacy laws that have been enacted by many states, then there are a number of obligations that you'll have with respect to that data. So maybe it's worth asking a question. Do you think there are common concepts that run through all privacy legislation worldwide? True or false? There are common principles that run through all privacy legislation, or a lot of privacy legislation.
It has to be true. How can it not be true?
Madan, you gotta let the class answer. I want to send someone all right, gift card from Madan.
Okay, I'm so also from you.
The answer is true. There are these fair information practices that are codified with relative consistency worldwide. They're reflected in the GDPR principles. They're reflected in HIPAA. They're reflected in many privacy statutes. And so when you ask, what are your obligations to information that's identifiable under a privacy law? They include transparency at a high level, having a privacy notice that is available to individuals that tells them what data the business collects about them, how the information is being used, how it's being collected, what are the sources of the information, with which types of third parties is the data being shared, and explaining what kind of rights individuals may have with respect to that data. And the rights will vary depending on the law. Another principle, individual participation. So giving folks some choice about what happens with their data. Do you give them an ability to opt out of the receipt of certain kinds of marketing? Do you give folks an ability to opt out of the processing of certain of their sensitive types of data? Purpose specification. Letting individuals know the purpose for which you're collecting the information and not using the information for any other purpose unless you go back to the individual and give them notice and consent. And this is something that the Facebooks of the world have had a very hard time with. They had gotten lots of trouble with our Federal Trade Commission because they would collect data for one purpose and realize it's very valuable, going to use it for a totally different purpose, not tell people what we're using, and it gets them in very big trouble, huge fines. Another principle, data minimization. Only collect data you need to serve the purpose for which you've said you need it, and then don't retain it when it's no longer necessary for that purpose. And that's actually a really good risk mitigation strategy too. I see fact patterns with incident and breach response where you see that businesses perhaps retain data that they no longer need, and then it can be subject to a breach. A bad actor gets hold of it, and that wouldn't necessarily have happened to as great a degree if data had been deleted more regularly. Yes.
Wait, just 1 second. Chiradeep, you want to ask the question? It looks like you had a question.
Yeah, it's related basically a little bit from this, like for the automobile industry. There's this comply auto banner that comes. You would see, like, especially most of the dealers you see, they have a banner that will come at the bottom right, which will say, hey, accept or decline with a privacy note. And then you click into the link, you can actually go and read. They'll say right for access, right to forget, right? I've tested this a bit. And one of the questions I have is, let's say a dealer or a DMP, they some kind of a tech partner, they're putting a cookie on the first party domain of the dealer website. What happens is you say it's a first party cookie because it's on the dealer domain website, but that cookie basically represents the user's browser or phone device ID, and you start using it in all your targeting and everything that you do in the marketing side. The question here is that banner there, it clearly says that your accept or decline is for third-party cookies. But those people, the comply auto people, what they'll tell you is if somebody declined, you cannot also use first-party cookies. I really want to know, like, legally, I've tried to work with attorneys on this, like it's a gray area. Is that banner really referring to just third-party cookies, or it also refers to like first-party cookies which might target users, even though they write third-party cookies at the end of the day?
So under the EU's kind of cookie directive, their e-privacy directive, you're supposed to get the consent of users, and also in connection with GDPR, you need to get consent of users for use of cookies that are not essential to operate the website or service. So you have the banner, and it should give individuals choice about anything other than that which is strictly necessary. So whether it's a first-party cookie or a third-party cookie, if it is not strictly necessary for the site to operate or the service to operate, then you should be getting a click accept to it. Does that answer your question?
It does. If you're saying explicitly they have to click on accept for us to use, irrespective of the type of cookie, then yes, it's clear.
Well,
Yeah.
if it's not strictly necessary to operate the service, and that's really an EU piece. It's not, that is not strictly that is not a requirement of our emerging US laws. This is an EU driven requirement.
Which is a more stringent requirement compared to
yes,
right?
Yes.
Got it,
But
yeah.
you know, if you go back to these principles that this individual participation and giving individuals choice about what data you're collecting, you can never go wrong with getting a consent. So even if you kind of get over consents, I mean, beyond that which you truly need, you're going to be in a much better position, and it's cleaner data too. You know, because if you've just gathered all this data, you never got any consent for it. Oh, it might work for this regime. You could use it for people in this jurisdiction, can't use it for others. Just go ahead and get the consent. Now, technically, if you don't make them click accept, I don't know how meaningful it is. The consent is supposed to be some manifestation. And so simply Xing out the box, I don't know that that really is a meaningful consent. I mean, I think it probably doesn't meet what we would consider the consent standards, to have an express manifestation of the individual's choice. Excellent question. And feel free to ask questions as we're going through this. All right. We were now at security. So security is a concept that runs through most privacy legislation. And, you know, there can be a sliding scale of what security measures are required depending on the type of data we're talking about. GDPR is actually pretty light when it comes to specific granular descriptions of what security is required to protect data. You know, there's this reasonable and appropriate, you know, depending on the risks to individuals. Here in Massachusetts, actually, we have a data protection law that has very specific and granular requirements, but over a very narrow class of data. So it's that name and social, name and financial account number. They're very specific safeguards that businesses need to implement when they handle that kind of sensitive data of Massachusetts residents. And they need to have a written policy, actually, that expresses certain safeguards from an administrative, technical, physical standpoint as to how the data will be protected. And then the last concept that runs through most of these laws would be some kind of accountability and auditing, that there are individuals charged within the business to be responsible for privacy and data security, and that there is auditing, that there is assessment as to whether these practices are being upheld.
Fantastic. Wow. What a great exposition. Okay, now let's start with how many states actually in the US actually have privacy legislation already passed or in passing?
Okay, so the number of US states that have enacted comprehensive privacy legislation is 12 right now. So we have, California, Colorado, Virginia, Connecticut, Utah. So the list is expanding. Only 3 are effective right now. So between now and 2026, we're going to have a lot more states that are active. President Biden, in fact, just in the last couple of weeks, as the president has done every year since maybe the last 5 years, I would say, because I've been working in this space a long time. In the beginning, it was kind of like, what privacy? But now everybody's on the bandwagon. But there are calls, as there have been calls year over year, for bipartisan federal privacy legislation in the US, but I don't know if we'll get it. Bottom line, 12 right now and 3 effective. And maybe we should talk, well, you tell me what you'd like to talk about.
Okay, next question for you is that we talked about common principles. Okay, now tell us a little bit about, in the US at least, as defined by CCPA, amended by CPRA, what is sharing, what is selling, and what are the obligations? When am I sharing data and when am I selling data? It looks like there's a significant legal difference between those terms. Maybe you can educate us a little bit on what that means.
Yeah, definitely. And you do see some of the emerging state laws in these other states beyond California picking up these concepts as well. But for simplicity, I'm just going to talk about California right now. So sale would be making available to a third party personal information, realize broadly defined, anything about an identified or identifiable natural person, making available that personal information to a third party for anything of value. So it does not have to be monetary consideration. Certain of the emerging state laws go by a monetary consideration threshold. For CCPA, anything of value. Perhaps you make the data available to the third party gives you a reduced rate for a particular type of service. Absolutely. There's a sale there. Now, the distinction between what's a sale and what's a share, this is a little bit of a tricky business. And there was a case under the CCPA where Sephora ended up having to pay a 1.2 million settlement to California regulators to settle a case that they had been selling data and not disclosing in their privacy policy that they sold data, and not giving individuals an ability to opt out of that data, which two of the biggest obligations that attach to businesses that sell are say that you sell, and their particular magic words that the CCPA, as amended by CPRA, says that you need to explain that, and give individuals an ability to opt out of it. So what happened with Sephora is they were making available data about users of their site to third parties that were permitted to use the data for their own purposes. And, you know, in exchange, perhaps there were ads that were sent to various users, and Sephora was getting a benefit from that, but they weren't disclosing it. And so the CPR, yeah.
Sorry. So almost everybody in this class knows what pixels are. And we are constantly putting pixels on either our own sites or our client sites and retargeting those users on Facebook or on TikTok, whatever. Is that sharing? Is that selling? Is that nothing? What is that?
Yeah. So I would say, let's say you have the pixel, third-party pixel on a platform. User A goes to the platform. User goes to another site, you know, maybe the site where that's operated by the third-party pixel, receives an ad for the original service of the site that they visited. I think that's pure retargeting.
Yeah.
I don't think that is a share.
That's not a share. Okay. That's not a sell either.
No, because it, unless perhaps, well, here's an unless, provided that the operator of the pixel can't do anything else with the data other than provide the service to the original platform.
Okay. So when I put a Facebook, let's say I am a e-commerce site, I sell some shoes or something like that. I put a Facebook pixel on my site, and is now Facebook allowed to use my data for anything else other than serving ads for me? What is the Facebook policy? You know,
well, Facebook has multiple kind of options that they can make available to the provider of the original site. And if you want to not be considered selling, you need to restrict the dropper of that pixel, the placer of that pixel, from doing anything with the data on that site other than provide the service to you. So you have, I believe Google and Facebook will have that option.
Okay.
Now the sharing piece though. So this is sharing was a kind of new class of behavior that was regulated by the CPRA as it amended the CCPA, and in part inspired by the Sephora fact pattern. So sharing is when you make available to a third party, with or without any consideration, any kind of monetary consideration, personal information for the purposes of cross-context behavioral advertising. I'm going to read you the definition there of that, because that is and it's a very specific definition, and it's different from basic behavioral advertising. So it would be targeting of advertising to consumer based on the consumer's personal information, based on obtained from the consumer's activity of cross businesses or distinctly branded websites other than the business with which the consumer intentionally interacts.
I see.
So I go to, let's say, the Walmart site, and whoever's has the pixel on the Walmart site knows that IP address that's associated with Faith went to Walmart site. Now, when I, Faith, with my IP address are on another site, I'm going to get an ad for maybe CVS, because it's been the information that's being shared is my IP address and the fact that I visited the Walmart site.
Right.
And from that, an inference is made. Faith might be interested in an ad for CVS. So that's that information that's being shared, made available, is my IP address, the site, the original site I visited, and now I'm going to somewhere else and I'm going to get an ad for CVS.
Right. Who's responsible for this compliance? Is this Facebook or is this Walmart? Who needs to make sure that this doesn't happen?
Walmart is sharing, because Walmart is allowing whoever is putting that pixel on the site to use the information. So what you want to do, if you do not want to and so your obligations with respect to sharing are the same obligations you have pretty much with respect to selling. You have to tell users that you're doing it, and you have to have that do not sell or share my information button, and you have to be able to opt individuals out of it. You know, there are also other obligations. You're going to have to, the site would have to be able to comply with the opt-out preference signal once the CPRA regs go into effect. So they need to be able to operationalize an opt-out simply based on the browser signal. Bottom line is there are obligations, and if a site does not want to have to comply with those obligations, they need to make sure they're not making data available to a third party for the purposes of cross-context behavioral advertising. And it'd be whoever's dropping the cookies or the pixel who need to be contractually prohibited from doing anything with the data other than provide the service to the site that's being operated.
This is probably relevant for sister sites. I mean, if you guys have, you know, Instacart's in the class today. If Instacart has a sister site, a sister brand, then this becomes very relevant because the consumer interacted with Instacart, not the sister brand. So if you're going to serve ads for a sister brand, then you got to have to like put some compliance notices on Instacart to represent the fact that you might use it in this particular context. Wow, amazing. I got an education today. All right, let's pause right there. Questions? Is there a particular case outside of Sephora that is in the courts right now that would necessarily change how we interpret any of the stuff?
Well, not necessarily how we're changing things, but you have to realize, I guess it's worth mentioning that the large platforms and the behavioral advertising practices of those large platforms are not viewed upon favorably by the European regulators. And there was, you know, just in the last couple of weeks, a sort of a ban on making final a ban on Facebook for their data processing for behavioral advertising purposes. Essentially, there was an interim ban that was applied in July. It was set to expire November 3rd. And then Facebook, as a kind of alternative option, said, well, it was in connection, I should say Meta offered in connection with the Facebook and Instagram services, well, we'll make a paid subscription model available to EU users. And there won't be any behavioral advertising if you are a paid subscriber to Facebook or Instagram. And I think the European regulators found that really didn't pass muster. And you're also seeing Google's targeted advertising practices also viewed as problematic. So, I mean, I think this whole industry is really in flux now and caught between kind of multiple regulatory schemes that really want to provide more of these kind of fair information practices to users with respect to their data.
Phenomenal. Great, amazing education here. Okay, let's pause. Class, questions for Faith? Anything else that you want to leave? These are all practitioners in the space, so this is all incredibly relevant. But anything that's coming at us that we should know about? There's a lot of, as you said, the stuff we talked about with respect to the EU and Facebook. Anything else like that as leave behinds for us?
Well, I think we just have to be aware that this is an area that is still under tremendous change, and the laws are proliferating and changing in real time. And I think depending on the size of the enterprise, you really want to keep always want to keep the fair information practices in mind. But the larger the enterprise, the less tolerance there will be by regulators and consumers for violations of data protection rights. So, and I do see lots of activity from consumers, like in consumer groups, advocating and going after businesses and complaining about businesses that don't comply with these laws.
Yeah, actually, Joseph, exactly that's my question. Like varied industries, automobile, especially, companies who try to target people with emails, phone numbers, texts. I've seen a lot of this advocacy groups, like you said, privacy activists. The request actually comes from these groups. Do you see a lot of end users actually going out and filling up those forms? Like I have myself sometimes gone and filled up. I never got an answer back from the companies. Like, like I said, hey, can you please tell me what data you have about me, my email, my phone number? And then I never received a reply back from them. And in fact, with that, they would write a note saying, hey, like, sign some kind of a signature saying, I can be sued for like asking for data which doesn't even belong to me, right? If you're like putting an email, Madan's email in my request, that's supposedly wrong on my part to be doing that. So somehow I feel, consumers are also pushed back when they give such a request. Like, statistically, do you see like really a lot of requests coming from consumers, or it's actually these activist lawyers who are really raising these requests?
So I do see complaints being raised by individual consumers. I see individual consumers exercising their data subject rights, asking a business, what do you collect about me? How are you using it? How are you sharing sharing the data? Asking to have data deleted, which certain of these laws will give rights. But just realize EU gives rights, California gives rights, these states as they're emerging will give consumers certain rights. Many states don't give individual rights because they don't have the legislation. One other tricky point to mention is that depending on how a business falls within scope of GDPR, like if they're established in the EU, then they need to treat all data, regardless of location of the data subject, in compliance with the GDPR. So that's how you could see folks from other jurisdictions getting GDPR rights. But to answer your question, perhaps the businesses that didn't respond to you, where do you live?
In Chicago, Illinois.
Okay, so Illinois does not have comprehensive privacy legislation.
Right, yeah.
So yeah, you're in the same boat as me in Massachusetts. We don't have the rights Californians have. But I think it's a matter of good business practice to respond, to individuals. Certainly, our CAN spam law in the U.S. requires businesses to allow individuals to opt out to the receipt of commercial marketing messages. But you did also mention text, and that's something that's absolutely worth mentioning. That's a very active area, both in terms of plaintiffs' attorneys filing class action lawsuits against businesses that violate our Telephone Consumer Protection Act, which extends to text marketing. So text marketing, you absolutely need to get a very explicit opt-in for any kind of text marketing, prior written consent. I recommend like the double opt-in where the individual says, yes, I consent to I consent to receipt of text marketing messages. And then the first message should be confirm your choice. Yes, I do want to receive text marketing on this number.
Interesting.
Yeah, great points. Thank you so much.
Super insightful conversation right there from a pretty unique perspective. So as more brands become data forward and AI becomes more mainstream in the analysis process, it's essential that legal and regulatory bodies keep pace to protect users, clients, and businesses alike. As Faith mentioned earlier, the EU's GDPR data privacy framework is already pretty robust and far more advanced than the US's current protections. But privacy acts like California's Consumer Privacy Act, or CCPA, is starting to catch up. Also, random fun fact I realized, being good with acronyms seems really helpful in the legal space. So if you're trying to go into the legal space, that might be something to consider. Anyway, working at Morse in Boston, Faith has tons of experience in legal niches such as general corporate, employment, litigation, intellectual property, and data protection. This range of services requires a team with diverse expertise, and that's one of the challenges of being a small to medium-sized firm in the business. Like any industry, it's cutthroat competition for resources and talent. This is especially true in law because the field requires an especially high level of education and expertise. I mean, just take a look at how the definitions of PII based on specific privacy laws change, right? Whether it's covering breach notification laws, COPPA, which is Children's Online Privacy Protection Act, HIPAA, which is the Health Insurance Portability and Accountability Act, GLBA, the Graham-Leachy-Billy Act, or comprehensive privacy laws as a whole. So for all you marketers and attribution enthusiasts tuning in, you may ask, so what? Why do I have to care if I can leave it up to the IRL cast of Suits? And yes, for those that haven't seen the show, I mean lawyers. Data privacy laws have a profound impact on the attribution landscape because they directly affect how data can be mapped. With more stringent legal protections, it limits the scope of businesses to link online engagement touchpoints to certain users, and this is actually a good thing for consumers. But businesses have to adapt, and we see this with the resurgence of MMM, as other guest speakers have pointed out on previous radio episodes. And yeah, shameless plug, highly recommend you checking those out. But to sum it up quickly though, MMM, or media mix modeling, solutions are top-down perspectives of every aspect of a business, and attempt to understand how each aspect contributes to a business outcome. While MTA is a bottom-up approach, attempting to meticulously measure every consumer exposure to media and then attribute each exposure to a website visit or online sale. Basically, MMM is the bird's eye view using more macro trends to understand consumer buying preferences. So Faith mentions that 12 US states have enacted comprehensive privacy legislation, with only 3 currently effective. This makes understanding the legal differences and boundaries of selling versus sharing data for profit critical. And if you want to know why it's critical, just see the Facebook Cambridge Analytica data scandal for reference. Under the California Consumer Privacy Act, selling involves the exchange of data for monetary value, right? So money basically. While sharing encompasses providing data to third parties for business purposes. So Sephora was our example of choice about the legal consequences of what can happen when you don't disclose what you're sharing consumer data for and what kind of personalization processes that entails. This is why there are implications for companies using pixels for retargeting, aka lower funnel dealings, as well as via contractual restrictions. She also touched on marketing consent laws like Telephone Consumer Protection Act and text marketing compliance, which basically means you can't break people's sleep schedules to push your business. So probably not a good way of getting customers anyway, but that's neither here nor there. But I could go on, because the legal policy of this stuff is really interesting for me personally. But I think this is a good time to wrap it up. And big shout out to the pod for yet another great episode. And for the viewers sticking around this long, make sure to smash that like button and subscribe button for more attribution wisdom. So until next time.